Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. After more than 10 months, the NLRB may be getting close to a quorum. Some are predicting significant precedent shifts once the board is fully operational. But there may be more to the story. Epstein, Becker, Green's Corey August tells us what employers can expect from a full NLRB and what may take more time.
The National Labor Relations Board, which is a 5-member board, requires 3 members for a quorum for the board to carry out its normal functions. Currently on the board is David Prouty, who was confirmed in 2021 with a term that runs through August of 2026. Prouty is a union side attorney who's previously served in general counsel roles in multiple unions, and he is at the moment the lone Democrat on the board.
There are currently 2 Republican board nominees awaiting Senate confirmation. One, James Murphy, has been reported out of committee and is pending confirmation before the full Senate. Murphy is a career NLRB attorney. He's been nominated to serve until December 2027. The other nominee, Scott Mayer, is pending before the Senate Committee on Health, Education, Labor, and Pensions. Meanwhile, Crystal Carey, the nominee for General Counsel, has also been voted out of committee, awaiting full confirmation before the Senate.
Once the board does resume a quorum, we expect them to continue their normal activities like issuing decisions. In the interim, hearings have been canceled, elections have been canceled, and essentially everything is on hold. There's a significant backlog. This has been contributed to by the government shutdown.
Well, the board is expected to rule quickly on pending cases. Those predicting major changes in underlying precedent may have longer to wait.
Historically, the board's practice has been to refrain from overturning significant precedent unless there's a 3-vote majority to do so. So even if a quorum is reached with the 2 Republican nominees confirmed by the Senate, we don't necessarily anticipate the overturning of major precedent until Republican board members have 3 on the board. This is not a statutory requirement, but generally, historically, the board has had a 3-2 majority split, with the majority being the party of the current administration. And that's not a statutory requirement, like I said, and given all of the departures from the norms that we've seen in the recent past, that's something that could potentially change as well.
Thanks, Corey. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.